The present batch of appeals has required the court to engage with questions that lie at the intersection of personal liberty and collective security. The guarantee of liberty enshrined in Article 21 of the Constitution is of foundational importance, and no constitutional court can be unmindful of the gravity of restraining liberty before guilt is adjudicated. At the same time, the Constitution does not conceive liberty in isolation. The security of the community, the integrity of the trial process, and the preservation of public order are equally legitimate constitutional concerns. When bail is sought in prosecutions governed by a special statute, the court is required to undertake a difficult and sensitive balancing exercise, conscious that neither liberty nor security admits of absolutism. While undertaking this exercise, the court cannot proceed on any consideration except restricting the contours of inquiry confining to law, where Parliament has prescribed a distinct statutory threshold for the grant of bail, and where the prosecution places prima facie material suggesting organized and deliberate activity affecting public order and security of the nation, the court cannot turn a Nelson's eye to such material merely because incarceration is prolonged or liberty is invoked in abstract. Equally, where continued detention is not shown to be necessary to serve a legitimate purpose recognized by law, the court must not hesitate to restore liberty subject to stringent conditions that safeguard the larger public interest. The position of law that emerges may be stated with clarity. The right of personal liberty enshrined under Article 21 is of seminal importance, and prolonged pre-trial incarceration is a matter of serious constitutional concern. At the same time, where the Parliament has, in context of a special statute, conditioned the grant of bail upon the satisfaction of a defined statutory threshold, the Constitutional Court cannot treat such restraint as avoidable. Section 43D5 of the UAPA represents a legislative judgment that offences alleged to implicate the security of the state warrant a distinct bail regime. The constitutional role of the court, therefore, is neither to mechanically enforce the statutory embargo nor to neutralize it by invocation of liberty as straitjacket formula, but to apply it with disciplined scrutiny. Where the prosecution material taken at face value discloses reasonable grounds for believing the accusations to be prima facie true, the statutory restraint must ordinarily operate. Where it does not, liberty must prevail. Article 21 thus commands the manner of an application of the statute. It does not dissolve the statutory condition itself. It is in this constitutional and statutory framework that the individual appeals have been examined based on facts obtained. The courts has consciously avoided a collective or uniform approach. Each has been assessed on the basis of the role attributed, the nature of the material relied upon, and the stage of the proceedings, strictly within the limited compass of adjudication for grant of bail. This court is satisfied that the prosecution material taken at face value as required at this stage discloses a prima facie attribution of a central and formative role by the appellants in appeals arising out of SLP criminal number 14165 of 2025 and SLP 14030 of 2025, Umar, Khaild and Sharjil Imam in the alleged conspiracy. The material suggests involvement at the level of planning, mobilization, and strategic direction extending beyond episodic or localized acts. The statutory threshold under 43D5 of UAPA therefore stands attracted qua these appellants. While the period of incarceration undergone by these appellants is substantial and has been duly considered, the court is not persuaded that on the present record, continued detention has crossed the threshold of constitutional impermissibility so as to override the statutory embargo. The complexity of the prosecution, the nature of evidence relied upon, and the stage of the proceedings do not justify their enlargement on bail at this juncture, as noticed in detail in the discussion made herein above. Hence, the appeals arising out of SLP criminal 14165 of 2025 and SLP criminal number 14030 of 2025 stands rejected. We reiterate that courts are under constitutional obligation to ensure that criminal proceedings, particularly those involving prolonged pre-trial incarceration, should progress with utmost expedition and the accused are not left to languish in jail. At the same time, the court is mindful that pre-trial detention, even when justified by the statute, cannot be permitted to continue without regard to the progress of the trial. The restraint on liberty contemplated by law must proceed alongside a meaningful advancement of the prosecution. In the present case, having regard to the reliance placed upon the protected witnesses, this court considers it appropriate to provide a defined point for consideration of their prayer for grant of bail. We are of the opinion that on completion of the examination of the protected witnesses relied upon by the prosecution or upon the expiry of the period of 1 year from the date of this order, whichever is earlier, these two appellants would be at liberty to renew their prayer for grant of bail before the jurisdictional court. In the event of such prayer being made, it shall be considered on its own merits, having regard to the stage then reached in the proceedings before the trial court and without being influenced by the impugned orders or the present order. This course gives effect to the statutory discipline embodied in section 43D5 of the UAPA while ensuring that the constitutional guarantee under Article 21 operates as a continuing check against continued incarceration without there being any substantial progress of the trial. The appeals arising out of SLP 13988 of 2025, Gulfisha Fatima, SLP criminal 14132 of 2025, Miral Haider, SLP number 14859 of 2025, Shifa ur Rahman, SLP number 15335 of 2025, Mohammad Salim Khan, and SLP criminal 17055 of 2025, Shadab Ahmad are allowed. As the court is of the view regard to the role attributed, the nature of the material relied upon, and the present stage of the proceedings, continued incarceration is not shown to be indispensable to the conduct of a fair trial, provided strict safeguards are imposed. The grant of bail in their favor does not reflect any dilution of seriousness of the allegation, nor does it amount to finding on guilt. It represents a calibrated exercise of constitutional discretion structured to preserve both liberty of the individual and security of the nation. The appellants granted bail shall be released subject to the following conditions which are imposed not as a matter of form but as a substantive safeguards in the interest of national security, public order and integrity of the trial process. We have imposed about 12 conditions. And we have said in case of breach of any of the aforestated conditions imposed or in the event of appellants having misused the liberty granted, it shall be open to the trial court to cancel the bail, which would be necessarily after affording opportunity of hearing to the appellants. Before we conclude, it bears reiteration that a principle lies at the heart of constitutional adjudication in matters of this nature. The constitutional guarantees personal liberty, but it does not conceive liberty as an isolated or absolute entitlement detached from the security of the society in which it operates. The sovereignty, integrity, and security of the nation, as well as the preservation of public order, are not abstract concerns, rather they are constitutional values which Parliament is entitled to protect through law. Where a special statutory framework has been enacted to address offences perceived to strike at these foundations, courts are duty bound to give effect to that framework, subject always to constitutional discipline. In the application of such law, the court does not proceed on identity, ideology, belief, or association. It proceeds on role, material, and the statutory threshold governing the exercise of jurisdiction. Criminal law does not mandate identical outcomes merely because allegations arise from the same transaction. Those alleged to have conceived, directed, or steered unlawful activity or terrorist activity stand on a different legal footing from those alleged involvement is confined to facilitation or participation at a different level. To disregard such distinction would itself result in arbitrariness. The present decision reflects this constitutional method. It neither endorses the prosecution case nor prejudges the guilt of any accused. It applies the law as it stands, recognizing that individual liberty must be protected, but that it must also withstand the legitimate demands of national security and collective safety. This balance is not a matter of preference, rather it is a matter of constitutional duty. Before parting, it is necessary to reiterate the limited nature of the present determination. The court has not examined the merits of the prosecution case beyond the confines mandated at the stage of consideration of an application seeking bail, or has it expressed any opinion on the ultimate culpability of any accused. All the observations are confined to the material present on record to the statutory and constitutional standards governing pre-trial liberty under a special enactment. Having regard to the nature of the prosecution and the period of incarceration already undergone, it is considered appropriate to direct the trial court that the trial court shall proceed with the matter with the due expedition and shall endeavour to ensure that examination of witnesses, particularly the protected witnesses relied upon by the prosecution, is taken up and carried forward without any delay. The prosecution shall take all necessary steps to secure the presence of its witnesses on the dates, and parties shall refrain from seeking adjournments except for reasons which are unavoidable. The trial court shall be at liberty to regulate the proceedings in accordance with law so as to ensure that the trial is not unnecessarily prolonged, while at the same time safeguarding the rights of all parties. It is clarified that these directions are issued in furtherance of the obligation to ensure fair and timely trial and shall not be construed either as an expression on the merits of the prosecution case or as a constraint on the discretion of the trial court in the conduct of the proceedings. The trial court shall remain free to adopt such measures as are permissible in law to ensure that the trial proceeds with continuity and at a reasonable pace, consistent with the requirement of fairness and the orderly administration of criminal justice. There would be something amiss in this judgment if we do not place on record the able and arduous assistance rendered by learned senior counsels led by Sri Kapil Sibal, Sri Abhishek Manu Singhvi, Sri Salman Khurshid, Sri Siddharth Luthra, Sri Siddharth Dave, Sri Diddhat Agarwal, and learned advocate Gautam Kazansi and their team of lawyers appearing for appellants, including the painstaking efforts put up by Sri Tushar Mehta, learned Solicitor General of India, and Sri S.V. Raju, learned Additional Solicitor General of India, and their team appearing for the state, respondent state, and the law clerks from research associates for assisting this court in rendering this judgment expeditiously in the background of voluminous records, lengthy arguments, and katana of judgments relied upon.